before you get started, there was some filings today as a response to the late filings yesterday.
Okay, so let me ask, because the last thing I see in Odyssey, and let me go back because I'm printing these from email. I have a motion. Are you talking about the motion to strike plaintiffs?
Yes.
Affidavit and first amended petition? Okay.
Yes.
Is that it, Mr. Martinez? Do you have anything that was filed today? I received these via email. I do not see them in the Odyssey.
Judge, yeah. So so this all started in June when we filed our motion to continue this hearing. That should still be pending. And then we filed a supplemental motion to continue, and highlighting all the reasons why. And then obviously we have the response that we filed yesterday.
So the only question I have right now before I call it is, did you have anything that you filed today that I may not be seeing either in Odyssey or may not have received via email?
I don't think so. Like, you
Okay.
should have those three pleadings in front of you.
I do have your first amended petition. I have everything that you filed through yesterday, I believe.
Okay.
But if there was anything today, since this is kind of a lot of movement, I want to make sure that if you had anything today, I'm not seeing it on Odyssey.
Oh,
and
yeah,
so
we didn't
Nope.
file anything today.
Today. Okay. And then when was the last hearing? Because I thought we were here with Mr. Unterrecker at the last hearing. Was that July 19th?
I believe
Yeah.
so. That would have been with Mr. Interrecker.
Okay, I just wanted to make sure I had my timetable okay. All right. So let's call it.
Because number 2022 DCV 1835 Lorenzo Juarez versus El Paso County, Texas. Announcement of council, please.
Ray Martinez on behalf of plaintiff.
Michael Gomez for the County of El Paso.
And we are scheduled today for a hearing on the plea to the jurisdiction. I was asking counsel off the record regarding, I guess, recent filings. I believe I have everything that may not be reflected in Odyssey, things that were filed today from the county attorney. And I don't believe Mr. Martinez had anything filed today. And I do have everything that was filed up through yesterday. So I just want to make sure I cover that. Before we get started on today's hearing, though, with respect to plaintiff's motion for continuance, which was set on July 19th, I don't recall coming to a point of resolution on the motion for continuance at the last hearing, because Mr. Gomez, I believe Mr. Unterrecker from your office was covering on that date. And the court's recollection is that there was some discussion between Mr. Martinez and Mr. Unterrecker. Things were going to get looked at, but there was no ruling by the court on a motion for continuance. Mr. Martinez, is that what you recall from the last hearing?
Yes, yes, ma'am. And in fairness to the county, so I believe Mr. Unterrecker was just covering, and so he didn't know, all the details. And I believe we kind of discussed, okay, well, let's try to resolve this through discussions with Mr. Gomez. I can't recall if Mr. Gomez was on leave at the time or what have you, but in all honesty, we haven't either there's been no agreement or discussion to move the trial or conduct more discovery. So we've just sent more discovery, asked for depositions, and everything's just kind of still on hold.
And if
And
I may,
you may, Mr. Gomez.
I have my notes. So the July hearing was a motion for continuance on the trial. We discussed that there was not really any need to do the continuance on the trial because there was a pending plea to jurisdiction, which undoubtedly would get appealed either way. The trial would be stayed during the pendency of the appeal, so the trial would be continued regardless. Thereafter, at the motion for the continuance with Mr. Unterrecker, there were discussions about the depositions not being in the possession of Mr. Martinez. The depositions were in the depositions were in the possession of all parties. that are cited in our plea to jurisdiction, we all have the deposition. So we were asking for a formal date on the plea to jurisdiction. Mr. Unterrecker did confirm that he was not familiar with the exhibits, so he did not know whether the depositions had actually transferred. So he agreed to postpone the plea to jurisdiction for, I guess, whatever day, 3 weeks, a month from the last hearing. And so we were gonna argue the plea to jurisdiction today with the understanding that Mr. Martinez would have some time to look at the depositions.
I disagree with that wholeheartedly. So what basically the discussion was that the reason, well, I should say my reason for pushing the discovery. Bottom line is, and you'll hear this throughout the plea of the jurisdiction, the plaintiff was fired basically for, according to the director, for lying about where he was. He went to this was during COVID. He's a dog catcher, and basically they travel around and in their vehicles, and of course they're constantly monitored via GPS and other means, so everyone knows where they are. Basically what he had done was he had, during COVID, when restaurants were busy and whatnot, he would or closed, he would go home. He went home 3 different times, and he would mark those either on the computer that's in their trucks, or he would put them on the daily log, or both. And all that information is given to the department management. What's interesting about this case is that the director has basically said, well, he's lying about where he is. We basically, our position, the reason for moving the deposition or the plea of the jurisdiction was to conduct the deposition of basically additional dog catchers, basically the supervisor in charge of dispatch, basically to clarify what we've already provided in the record, which is that whenever he stops, all this is well known, and he self-reported at all times. That was the reason.
Let me just stop you really quickly. What I'm trying to organize, or me, maybe I'm not understanding, and I know some of these things might overlap when we're talking about the plea to the jurisdiction and the motion for continuance, is the court never formally heard plaintiff's motion for continuance. And now I see in a recent file, and I hear what you're saying, Mr. Gomez, ultimately a plea to jurisdiction might make that move, but I want to make sure that I hear the motion for continuance independently and then get into the plea to the jurisdiction. Does that make sense?
Yes, sir.
And the reason being, because we had it set for hearing and I never really heard the merits of the motion for continuance. And so I'd like to hear your motion for continuance to include the supplemental motion to continue today's hearing so that I can rule on that, okay? So Mr. Martinez, and then I'll hear from you, Mr. Gomez.
Thank you.
Yes, Judge. So long story short is this case is not old. We filed this last summer. Basically, we in the normal course of things, the other side asked for a discovery order, scheduling order, understanding that, with schedules, with everything, the dynamics of litigation, that oftentimes one setting is not enough. And basically what we did was we sent out initial discovery. We scheduled the depositions of 3 different people, the director and basically a lead, like a supervisor, and basically another individual. What happened was, and this took place at the end of February, what happened was we basically got only to do the director, and that was agreed upon. Mr. Gomez was there, obviously, so we basically did the director, so we were unable to do the other 2. Then we didn't get the transcript back until May. And so after going through the transcript, basically I contacted the county and said, hey, need more time. They opposed. And so we filed this continuance in June.
Mr.
What
Martinez,
happened?
let me just stop you right there. So I'm clear and the record is clear. In June, you filed the opposed motion for continuance of pretrial deadlines and trial, correct?
Correct.
Okay, and so that was set for hearing in July and was not heard. And the supplemental motion that was filed 2 days ago is a motion to continue the pretrial deadlines trial, but also the hearing on the plea of the jurisdiction.
Yes, ma'am, because
Okay.
we had, what we had discussed, because, you know, again, regarding the continuance, and this is kind of the understated thing, is that basically, I wanted to make sure we had enough discovery to respond to their dismissal motion, the PTJ. And so that's why we're trying to move everything initially in June. And then after that hearing with Mr. Udiker, and there was nothing really happening, we supplemented our motion to be more clear that we needed the PTJ to be moved as well.
Okay.
So long story short is, again, not to oversimplify, but basically there's a notice of termination. I'm going to try to share this with you. Basically, it has to deal with a very specific reason for termination. Let me see here. Let's see, share. Okay. Let's see. So as I drag this over, oh no. Sorry, let's see. I think I shared the wrong screen. 1 second. Oh, maybe that was the right one. Okay, I think what you have in front of you is the notice of termination. This is the Exhibit L to our PTJ response. I don't know if you can you see that, Judge? Or...
I can.
Okay, so to be very specific, you know, the director cited 3 different instances here. Well, I'm trying to highlight this for you, but
Okay.
basically right here. And it's three specific days, 1 in January, 2 in February. And basically when a big point of hers, which was a part of the deposition that we cited in our PTJ response, basically what she found is she thought it was deceptive or dishonest, because she's basically saying, I didn't know where you were. And when you went home on the computer, it pops up as animal follow-up. And she says, you're lying. And that's the reason. And to be very clear, this is the only reason, and again, confirmed through a deposition, is the reason for termination. So the obvious question is twofold: is one is, was he being deceptive? And the other question is, how does this animal follow-up occur? You know, so in his affidavit and in the discovery and in the response, we've basically produced exhibits that make it clear. And this is exhibit, let me see, this is exhibit M, for example. This is on one of the days, I believe, you know, so they come up as, see, this is one of the 23rd. It comes up as follows. So he's putting in his address, and then he's even putting down break. And it just, what he says in his affidavit is that this automatically pops up or is coded as animal follow-up. Like, that's not within his control to change that. And that's consistent. That's basically happened the other 3 times. Every time he goes there, it stops. And so, and of course he's already brought, so to me, part of the discovery, some of the written discovery that's been sent is that basically we want all of his stops, you know, see if they automatically pop up as follow-up animal follow-up. and we asked for the other dog catchers. And again, the motion to compel is not in front of you. I was still in the midst of scheduling a discovery conference with Mr. Gomez. But the bottom line is, what I thought would be, very important to this case is, if every time the plaintiff stopped somewhere, did it pop up the same thing? And then if the other dog catcher stopped somewhere, did it pop up the same thing? So that's why we had asked this, basically the deposition for the supervisor of dispatch, so she could explain that. And because the director didn't know, when I asked her if this was automatic or not, she's like, I have no idea. And so the only testimony we have right now is the affidavit testimony of the plaintiff saying it is an automatic pop up. But to me, that can be easily verified through his records and the other dog catcher records. And just a big picture here, this is the county animal welfare control department. So basically, they have a very small staff. There's basically three. Mr. Gomez would know more, but as far as we can tell, there's only like 6, 7 dog catchers that are basically supposed to drive around outside the city limits, but within the county areas. So this is a large area that they're supposed to either respond to in person or respond to from dispatch, or drive around to patrol if they have no active calls. So all of those situations apply, but that could easily be verified through these records for just a handful of people. And so that's part of the discovery that we believe that would be very important. Not to say that's not the only thing, but we just haven't got that information. So when Mr. Gomez says that we have all the depositions, this case is ready to go to pleaders jurisdiction, that's not correct at all. That I've never indicated that. Basically, all I indicated, and maybe this is miscommunication, or something else, is that we took the director's deposition. We have all this information that came out. We didn't get the transcript till May, and basically I thought I've been very expedient in filing this motion as soon as I could. But instead, the county wants to close the door, and they filed their plea of jurisdiction, and that's why we filed our supplemental motion.
So let me be clear, Mr. Martinez, and then Mr. Gomez, I'll ask you to respond. I just want to make sure I understand. I understand what you're saying with respect to a motion to continue the trial setting. I hear what you're saying in terms of, well, there's additional discovery, there were some delays, and Mr. Gomez may contest some of those things. But then what is the basis for the request to continue the plea to the jurisdiction? Does it all overlap? Is it that discovery? The outstanding discovery or delays in whether you're receiving transcripts, getting additional depositions, or is there something in addition to that?
No, the only live issues right now, again, I am not, again, I don't know if it's miscommunication or just misinterpreting, but the bottom line is the only reason the depositions came up was because of we didn't get the director's transcript until May. And that's when we're reviewing that in May. Then we filed our motion in June. There were no other depositions taken. That's why I've requested the depositions of the dispatch supervisor and a handful of the other dog catcher people, and their records, basically. So discovery is the reason for moving the plea, the jurisdiction, and the trial.
Okay. All righty. Anything else on just the motion for continuance? I'll say the June motion for continuance and the supplemental. All right, Mr. Gomez, let me hear from you, please.
Thank you. I guess first, while we disagree with the characterization of the termination per se, Mr. Martinez has really brought nothing new. All the information that he is wanting to acquire or that he thinks is relevant has all been in front of him since really he spoke to his client. He alleges that he can get other information through depositions and whatnot, but I mean, in reality, all that information, the log sheets, the daily logs, the information has all been in his client's possession since day one. Moreover, there were depositions scheduled for other county employees but Mr. Martinez canceled those depositions. So I think at this time, I mean, we agreed to the discovery way back when, I can't remember, sometime last year. And the parties agreed, actually, we agreed to the discovery order in October 19, 2022. We agreed that depositions were going to be conducted a year later. And that was, I mean, really through agreement of both parties. And then we agreed that discovery would close on June 9th. We filed a plea to jurisdiction after the discovery order closed, really relying on the discovery dates, on the discovery deadlines, and relying on the discovery that was in front of presented to us as far as supporting their allegations. At this time, when we reopened discovery, we're essentially just taking another bite at the apple. None of the information that Mr. Martinez seeks was hidden or discovered through any depositions or through any interrogatories or through really any discovery that was presented. All the information that he wants could have been requested through different depositions, could have been requested, frankly, through interrogatories. But in reality, they're really not relevant because we're not contesting. Mr. Martinez is characterizing this as he's lying simply because he is writing something on his daily logs that appears to be truthful, but it's a little bit more complicated than that. I think once we go into the plea to jurisdiction, I'll be able to better explain what his duties were and what he was required to do. But just to give you a little bit of preview of it, it's not so much that he was documenting his stops or documenting what he was doing. It's the fact that he was doing so in a manner that was misleading. It's almost like if you have an employee, your employees go to lunch, you don't expect your employees to tell you, hey, I'm going to lunch. But if your employee documents and tells you, hey, I'm going to a doctor follow-up to go to lunch, and even though the doctor follow-up is at a restaurant, I mean, that is the misleading part. It's not so much the taking lunch or the documenting, it's just the misleading part of the way it was done. One last thing, I guess, as far as responding to the plea to jurisdiction, 11th hour last night, it's a little bit counterintuitive to Mr. Martinez's point that he does not have enough information to respond to our plea to jurisdiction when he clearly has done so. So given that we have both pleadings in front of the court, I would argue that at the very least, the plea to jurisdiction should still go forward.
So I just want to make sure let's see, discovery, when did discovery close? I'm trying to find the scheduling order.
June 9, 2023.
June 9th?
Yes.
Is that what I heard? Okay.
Yes.
And the motion for continuance was filed, the first motion for continuance was filed June 28th, correct?
It was after the discovery order.
I believe so, ma'am.
Where did I put it? Oh. Yeah, it's pretty. Mr. Martinez, what are you saying? I know you've mentioned this probably. Is outstanding in order to properly address the plea to the jurisdiction?
Well, we have a list which we've sent to Mr. Gomez of the individuals, and we've also sent supplemental requests for production. And frankly, we need to compel existing discovery, but again, in a nutshell, and again, I just want to clear one thing up is Mr. Gomez says we have everything. No, we just have what he chose to give us initially, just as an example. So we
Mr.
have
Martinez, let me stop you. You mentioned 2 requests. When were those sent?
The requests, they were sent recently, Judge. Let me check real quick. Yeah, we sent out the Well, the existing discovery was sent out since last year. The third, we sent out a third. The first and second RFPs were sent out before the discovery ended. We sent out a third RFP a couple of days ago on Monday. We sent out the list for additional people to send, I believe, recently as well. I want to say this week or last week.
So on the second, I guess the second request, not the ones that went out a few days ago, have there been responses?
No, they responded with objections. You know, that's the issue, and so we've conferred. I've sent a conference email to Mr. Gomez to confer on that missing discovery.
I may have missed this in today or a previous hearing. Did you all go to mediation?
No.
No, we haven't. That's part of our basis for the continuance. We haven't had a chance to go to mediation.
You were ordered to go to mediation by August 2nd, so that didn't happen.
Nope.
I guess why not?
You know, the last time we were here, we explained that there was really we felt the claims were rather frivolous. And that's what, we asked, when we spoke to the court, there was an understanding that when you asked us that we would not go to mediation. That happened at the motion for continuance, the first motion for continuance that got postponed before Mr. Antaricus.
The first motion for continuance.
You're talking about July 19th. Is that what you're talking about?
Yes, sir.
Yeah, there's only been one motion for continuance.
Hearing.
Right, but if we talked about it, then it got postponed to another day when Mr. Antaricus covered. I'm talking about the day that I was still present before Mr. Antaricus showed up.
That must have been July 19th. All right. Anything else on the motion for continuance?
Just a quick clarification, Your Honor. If Mr. Martinez has objections to something that was discovered, we have answered all our discovery as soon as it's been requested, as long as it was within the discovery deadline. As far as any conferences about the objective responses, the first conference that's been requested was 2 days ago, Your Honor. And so I just want to make sure that the court gets a fair characterization that we have not just hidden behind some type of blanket assertion of objections. We'd be willing to accommodate something that is needed if they bring us a legal and compelling reason to, but we have not had any discussions about conferencing till 2 days ago.
All right. Anything else, Mr. Martinez?
No, other than I think I've tried to move this case, Judge. I mean, basically, after the case was filed in June, I believe last summer, we filed our discovery. Basically in September, we filed our second RFPs, basically in October of last year. Defendant has supplemented. He's either giving me an objection, but I'm just identifying the specific information that has not been provided. I haven't been given any of the information that pertains to plaintiff regarding his stopping or how it's coded. And then again, just recently, and I need to double check, Judge, because I wasn't prepared to argue the motion to compel all of our discovery. But the bottom line is, I'm pretty sure I asked about it before. And then I said the most specific information that I could glean from the director's deposition just recently. And again, I think that information would aid the court or a fact finder and get to the heart of the matter, which is, was this a mistake, or was this normal, or was this an intentional act as the director said it was? And I think we can prove all of that through records and a couple of short depositions, or a few short depositions.
All right. Without anything further, then if you all don't have anything further on the motions for continuance, I am going to grant plaintiff's motion to continue both the trial setting and the plea to the jurisdiction. The request was for, I believe, 6 months. That was back in June. The trial date is going to be December 8th, with a December 6th docket call. The plea to the jurisdiction hearing is going to be reset to November 29th at 11 a.m. There is a new mediation deadline of November 28th. And we will have a status conference, a final status conference on October 25th at 11 a.m. as well. If you all need anything outside of those dates, if you all have any type of agreement on anything outside of that, or need any assistance or hearing from the court on anything, please let us know. Alrighty.
Yes, Judge.
Just as a point of clarification, so are you extending all the discovery deadlines or what's happening?
I'm not extending any deadlines. I am starting to hear from Mr. Martinez. He might have a motion to compel in the works. I don't know if that's going to be filed. If it is, by all means, Mr. Martinez, file it, ask for your hearing. We can have a hearing. If you all are based on the requests or what Mr. Martinez is saying outstanding, want to come to some type of agreement about extending the deadlines. It sounds like we have some depositions to take. I mean, I don't have a problem extending the deadline to that October 25th date.
Judge,
If there is a forthcoming motion to compel on things that I guess Mr. Martinez is claiming, I don't know, either haven't been fully responded, I have not received responses that are complete, whatever, objections, anything like that. The court is willing to entertain that, but I haven't seen anything.
Judge, I don't anticipate Mr. Gomez is going to agree to extend anything. Part of our continuance is to move the pretrial and the discovery deadlines. Can I get clarification? Can we move the discovery deadline to the status hearing at October 25th?
Yes.
Okay.
Then as far as the discovery deadlines also had limits on the interrogatories and requests for productions, are those?
What?
I'm not sure what's outstanding. I mean, Mr. Martinez.
Well, nothing was outstanding. That's sort of been our issue with Mr. Martinez's request. That we've done this, we've had about a year to conduct discovery. All the information has been known. You know, once it keeps getting repetitive, once after you responding to the same answer, you know, 15 times, that's what I'm trying to avoid. And so I don't want to just be having to respond to generic requests when there's no specific need for them. That, I mean, it's not necessary. Quite frankly, I mean, the whole point of a plea to jurisdiction is to allocate the county's resources to only those claims that have some merit. As the plaintiff, Mr. Martinez is the master of his own suit. He dictates how much discovery or how little discovery he wants to do within those discovery deadlines. And he agreed to a certain amount of discovery on the case, knowing his suit because he's the one that filed it. I would find it a little bit unfair, or rather unfair, to just reopen, just blanket reopen without any limitations, specifically when we have agreed to those and we have, you know, filed dispositive pleadings and relied on those to make our arguments.
Let me pull up the scheduling order. I haven't looked at it. Mr. Martinez, looks like you all agreed to, let's see, 30 requests for production, 30 interrogatories, requests for admission.
I can file a motion to extend discovery, I guess, Judge. You know, in the future, I'm going to want to get a much larger schedule order with Mr. Gomez.
Well, I guess that's what Mr. Gomez is saying is
yeah,
that
no, this is
certain limits, and now, you know.
Well, the judge, I don't know what these cases are until I get with them. I mean, just to say what and I don't appreciate Mr. Gomez characterizing me or my claims or my practice for me. Basically, at the beginning of the day, the defendant has all the discovery. The defendant has all the paperwork. And then in the context of employment discrimination, we have to prove these cases through circumstantial evidence. The defendant comes in very narrow.
So
And
let me just stop you right there, Mr. Martinez. Mr. Gomez, I hear your concern and I see exactly what you're saying with respect to the prior scheduling order. What I will say in terms of the limits, yes, Mr. Martinez, I am allowing more time because what I'm understanding is that maybe there are depositions that may have resulted from that one employee of the county, right? But you have sent multiple requests and the county has responded. If there is something within those responses that you need the court to hear some type of motion to compel, whether for whatever reason, file that. If you are asking to expand what has been limited by the initial scheduling order, then file that. I do hear you, Mr. Gomez, about having duplicate but I really can't guess what Mr. Martinez is thinking needs to be asked. If it's something in addition, for example, that comes out of a new deposition or new discovery, and I'm thinking primarily depositions in order to streamline. So yes, Mr. Martinez, you'll come back, and if you need something outside of what is in that the original limits of interrogatories, requests for production, file them with the court, and we can hear them.
Judge, can I just talk about what's the practicalities of dealing with Mr. Gomez in this case? So basically, so when we file the initial discovery, it's within the limits, usually generally speaking. And then as more information comes through, for example, in this case, there was a second RFP that's beyond, but it's much more specific. The one that I sent this week or last week to Mr. Gomez is, again, very, very specific. What I anticipate is Mr. Gomez is going to cut off basically just not respond to any of the discovery past the initial scheduling order. Do you anticipate, because for example, if you tell me that the county only has to respond to 30 or 45 RFPs, then I'd like the opportunity to at least choose those, because the initial ones that come out are designed as very general. And so I hate to be stuck with the official ones. Now I'm thinking with the county, I can't send out discovery until I take the depositions, so I can make that initial set as specific as possible. And so I guess what I'm hearing from Mr. Gomez is that he wants to limit the number to those originally agreed upon. I'd like at least to choose which 30 or 40 or 60 those are going to be, because this is a complicated case with GPS, and I didn't know, I don't know how their GPS works. I didn't know how all those systems work, and so that's kind of the issue. But I'll file a motion immediately, Judge, to expand, and I'll attach all the discovery that we've sent. And and hopefully we can get a ruling on that one, so I can get some genuine responses from Mr. Gomez.
So for now, I am not going to allow. For now, I think we need to wrap up what has already been requested and what has already been responded to, and clarify if these are. If they are responsive or failed to be responsive to requests already made that would have been governed by the previous scheduling order, or if they are new requests based on, for example, depositions that either you received very late, or in terms of the transcript, or that are upcoming. Okay. In that sense, in that vein, in other words, if there is a deposition next week, and based on the testimony that is given there, you know, this whole other world of questions come up and you need 20 more interrogatories or 20 more requests for production that were not subject of previous depositions or requests, the court is going to be open to hearing that. What I hear Mr. Gomez saying, though, is he doesn't want to receive 30 more requests that you have already made up until this point.
And
I'm not suggesting that happens. I'm not giving any, but I'm hearing just that concern. And so if they were existing requests that were not fully responded to, then file a motion to compel, file whatever it is that you need to receive relief from the court in terms of the responses. Okay?
Yes, Judge.
Okay.
Judge, I'm
Monday.
sorry, not to be a dead horse, just the practicality of the timelines you provided, especially the discovery order on all these depositions all the way to October 25th, and then the plea to jurisdiction on November 29th.
Mhm.
Practically speaking, if we were to conduct depositions on, let's say, October 25th, I would not have a transcript ready to respond or supplement my plea to jurisdiction by November 29th. So if the court is doing depositions all the way out until October 25th, then I would respectfully ask that at the very least get 90 days from that day to do the plea to jurisdiction. So that would have been, I guess, January 25th, just to give us time to get any transcripts that could come up if there's a deposition taken on October 25th.
And just to add with Mr. Gomez, I think we actually agree on that. You know, it took me 3 months to get the deposition I did at the end of February. So and this would also require us to do depositions like next week, in order to get the court reporter time enough to do that. And so I guess I'm just asking
Let me ask a question. With this scheduling order, how many depositions were taken?
There were 6 scheduled, only 2 taken.
one on each side, you know, and that's
what's concerning, because we entered a scheduling order in October of 2022, and apparently there's all this information and we only took 2 depositions.
Correct.
And that was the reason why, in terms of giving the plaintiff some consideration to do additional or follow-up depositions. But I'm not looking to extend this timetable so far. And I understand the practicality of, okay, if we're going to end in October, it's not practical to have the plea to the jurisdiction in November, but I'm not understanding what happened in a year.
Nothing happening.
Well, Mr. Gomez should know, because he's the one that sets the schedule with me for depositions. The first time the parties could agree on a deposition schedule was basically the last week of February. At the last week of February, we had scheduled the director and 2 additional witnesses. Basically, what came out in that deposition, Your Honor, is that one is that she considered that what the defendant produced was the whole grievance file from the civil service. If we're actually trying to get into all this, so what basically the reasons for upholding the termination at the grievance level was the notice of termination, which I just showed you, and plus all this other stuff. Like it was all this, his whole employment history. So and again, this is just life in the day of a plaintiff's lawyer. I have to chase all that information because they produced it. And so, and then at the director's deposition at the end of February, basically after took me 6 hours to get her to say this, but the bottom line is, no, what really mattered was just that notice of termination, just those 3 visits. And I thought the visits were dishonest or deceptive. So I don't get that transcript until May. I'm basically not getting that transcript until the end of May, and during May. And basically and Mr. Gomez got the transcript at the same time. And so I call Mr. Gomez, or we talk, I'm like, hey, we need more time, because this is this is not about the universe anymore. Now this is about how the computer system populates all these little screens, and how does that apply just to the plaintiff, or does it apply to all dog catchers? because there's that element of deception. That's what the director found deceptive, is when he went home for lunch, it popped up as animal follow-up. And so I got that information in May, basically saying, okay, this is the person. I don't know who to ask that from. So what she's basically saying, and my client certainly doesn't, but basically she says, oh, go talk to a supervisor in dispatch. That's probably your best bet. I can't even tell you if that's going to open up that Pandora of information. I don't. But what I do know is now all this information is due. I have a scheduling order that says, oh, my discovery closes June 9th. So that's why I'm trying to communicate this to the county attorney's office. And I try to set that hearing before I send out the additional discovery. And so what happens is we don't have that issue resolved. I don't set the motion to compel because on my prior to, because I'm trying to play nice. And then they basically take this approach, which is too bad, so sad, too late. And then I think that's very unfair, because now I'm like, okay, so I send out specific discovery. I send out specific names recently. And it's not because I'm late. It's not because I'm not, paying attention. It's because I was waiting on them. But instead, they filed this plea of the jurisdiction. We had to file a response.
I'm
So
not
we
really sure, Mr. Martinez, why once it became apparent to plaintiff that there was a whole, I guess, new level of issues with respect to the plaintiff's claims, why there wasn't a motion to the court to extend discovery, to just get trials. And I know you have a motion for continuance at the end of June, but that is already beyond the discovery deadline. And I understand that there was a delay in getting the transcript on that deposition if we're talking May, but it's really at that point where, I'm not going to tell people not to play nice, but where the court should have some notice if we're needing to extend these deadlines, because the deadlines were agreed to by both of you in October of 2022. So with that understanding, the court is going to change those dates. And since I do feel like it's not going to be something that is going to be agreed to, or we're going to have the discovery control plan, the new scheduling order is going to be based off a trial date in May of 2024. It's going to be May 17th. With that, the deadlines and limits, the corresponding deadlines and limits, just as we would on another discovery or scheduling order, will be the same, to include now in terms of the request for production, the request for interrogatories, request for admission, all of those are going to be, what I know this is, I don't know if I'm going to say this correctly. We're going to be the same limits, but now new. So what I'm saying is, on your scheduling order, there is a limit of 30 on the request for production, 30 on the interrogatories, 30 on the request for admission, and those are outside of those that have already been submitted to the county.
Point of clarification, Judge, and I don't know if Mr. Gomez is going to ask the same question. So there was the discovery that was sent in last year, and then there's the new discovery that I sent just recently. Would only the new discovery that I sent recently be subject to those limits?
The discovery that is subject to those limits is anything beyond the original June 9th deadline.
Okay. And I'm just trying to check real quick. I don't think we even sent, the only thing that was sent past the discovery deadline, again, because I was trying to hold to that order anyway, was the third RFP and request for depositions. So I would be limited to 6 depositions that haven't been taken since June, and 30 RFPs.
What did you all agree to on the depositions? Let me see.
6. Oh, 6 hours, I think, actually. Yeah.
Let me check
This
now.
total time to take deposition per side is 20.
Yeah, so there is no limit. Let me see.
Oh, here we go. Depositions, experts, 6/9 by indicate date. Oh, no limit there. Yeah, I mean, I don't see a limit, or if you're asking about a number of depositions, I don't see a limit there. It's, you know, what you all need to take within the timetable.
No, I agree, Judge. I'm just clarifying while we're all on this, on the record, any potential issues. I could anticipate an argument for that. Okay. I understand.
All right. The court is going to resubmit to you all a scheduling order. Okay.
Judge, one last request in light of all this, the discovery order and the new deadlines. To avoid an 11th hour response to a pleaded jurisdiction, can we get a date when a response is due for our pleaded jurisdiction?
So you're actually bringing up something that I already felt that I'm not inclined to set the plea to the jurisdiction at this point.
Okay.
I know with the original 3 dates, I was inclined to set it so we could just get things moving, right? And you could have a hearing on your plea to the jurisdiction in light of some additional limited discovery. But really what we're doing is resetting the case based on a plaintiff's motion for continuance. And so
I think the only concern that I would have is just for appellate purposes, we need to file before any dispositive motion deadline. Alternatively, it needs to be done within 30 days after some I forget the timeline, but for appellate purposes, we do need a deadline so that it would be considered and then forget the word interlocutory appeal.
So if we do, okay, so if we do a May trial setting, where is that going to put us in terms of closing out discovery? That's what I want to know.
Well, if you closed out discovery still on October 25th, I think that's plenty of time. I think we just need a pleaded jurisdiction. They 3 months.
No, I don't want to close discovery in October when the trial's in May. And again, if Mr. Gomez agrees to answer all my discovery and give me all my depositions by next week, I guess that could work. But I don't anticipate that. What I think is what's going to normally happen is you got to check on schedules and everything else. I won't get my depositions till, I don't know, you tell me, Mr. Gomez, but basically it's next month at best. And so I would argue for a discovery period like January or something reasonable like that, with dispositives in February. That's usually how scheduling orders are drafted. And again, this is a constant theme by the county, and specifically Mr. Gomez, Judge, is, he wants to give me 2 minutes to do discovery and hide the ball. And I just need to get this discovery done. At the end of the day, and I just for clarification, so the third RFP, which is the only one, only RFP written discovery after the original scheduling order, that one's they're numbered 59 through 83. So that was 24. My math is right. Yeah, that's 24 RFPs. So that should be within the new limit.
So I have no objections to starting depositions next week. We can get ready. That's fine, Your Honor. Really, I mean, realistically, October should be fine, especially since it is Mr. Martinez's position that he knows what discovery he needs. He knows what he wants. He knows who he wants to depose. So again, it's a matter of diligence. What I would hate is just to, again, postpone this, like, we're pushing this 2 years for pleaded jurisdiction, which is going to be argued and essentially appealed. I can guarantee you that GPS does not play any issue whatsoever on Mrs. Combs' decision to terminate. That's not going to even come up. So I don't know exactly what we're getting at. If he had a very specific request, saying something he's going to get, I mean, that's fine. The other thing that we're getting to now is that, you know, he is, realistically, what is really happening is we're fishing for discovery. He's going to try to find something, amend the pleadings to fit the discovery, and then we're going to have to do a whole new pleaded jurisdiction to respond to the pleadings, and it's going to be basically like 3 shots at the apple, which is what is happening already. And what we would like is just, I mean, stick to your pleadings, let us respond, let us defend our case. It is your case, bring in whatever evidence you have, and if you don't have it, you don't have it.
No. Okay,
Yeah.
so in terms of the settings that were October, November, those are not, I'm not contemplating those with the new scheduling order, Mr. Gomez. What I am doing is I am granting the motion for continuance. We're going to send you a discovery control plan and scheduling order indicating that May trial date. I am not anticipating that there will be anything beyond the numbers in terms of quantity of additional requests, interrogatories, requests for production, admission. Those are going to be the same. And then it is the time period, you know, wherever those deadlines fall are going to be the deadlines for depositions, discovery, all of that in terms of a timetable using the May trial date. That the November scheduling, rescheduling of the plea to the jurisdiction. No, I'm granting the request for continuance. Plaintiff is getting an additional period of time based on that continuance to conduct discovery. And when the county is ready to resubmit or refile another plea to the jurisdiction, we will schedule it accordingly.
And it would, just for appellate purposes, it would be a supplemental because we're still within our deadline.
Okay,
Correct?
that's
Yep.
fine. Mhm.
Yes, ma'am. And just again, so we're airing everything out. I would expect that the written discovery be supplemented prior to setting depositions, and that the depositions be scheduled soon, you know, September, October, in order for us to get all those transcripts, you know, by December, hopefully.
I am going based on a new scheduling order with a May trial date. Okay,
Yes, ma'am.
all righty. We're going to send you the scheduling order for you all to return to the court.
Thank you, Your Honor.
Yes, ma'am.
Thank you for your time.
Thank you.